Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, my name is Dorren.
And I am Raphael Leitz.
Welcome to Hull on Estates. You're listening to episode number 659. Today, Raphael and I will be discussing medical assistance in dying in Canada. It has been on the news quite a bit, yet again, recently. And it's also been sort of always been quite a cultural touchstone, I think. It's something that I see a lot in like movies and TV shows. I don't want to give any spoilers, but that one episode of The Last of Us that everybody keeps talking about, I was really surprised to like see that medical assistance in dying was quite a big part of that plot in that episode, although perhaps like there was no medical assistance to be had in a zombie apocalypse. You know, think you know what I'm getting at. I just don't want to spoil it for anybody, and it's just an incredible episode that I would encourage anybody to watch, even just like as like a standalone thing. Like you don't need to be into zombie movies or like even be like okay with them. That one is like really worth like the hour of your time. But back onto like today's topic. Medical assistance in dying came about in Canada in 2015 after the Supreme Court of Canada decision in Carter versus Canada, where it was found to be unconstitutional and contrary to the Charter of Freedom and Rights to have provisions of the criminal code that made it criminal for medical professionals to assist their patients with death. And so following Carter versus Canada, in 2016, you actually have like the first MAID regime in Canada where the federal government has put out like a process for everybody to follow. And in this like limited process, that's where individuals can qualify for medical assisted death in this country. But since that time, there has been, you know, like additional court cases involving MAID. In 2021, there was a decision out of Quebec that actually has now widened the regime to make the process available to individuals who are not terminally ill. And we're going to get into sort of like these two like groups of people and how like this whole process works a little bit later. But I kind of just like want to walk through like the history a bit because this is all still like very new. It's, you know, it's a decision in 2015 that like kicked everything off, made this available. The first system came to place in 2016. It's getting widened and changed again in 2021. And that's what we're talking about now in the news is because it's no longer a requirement that it be only available for terminally ill people. Well, what about people who are solely affected by a mental illness? And that is the reason why they would otherwise be eligible. And so right now the federal government is saying like, okay, we actually need a little bit more time to like really think about this like process for this particular group of patients. And they've asked to have until 2024 to really bring that into place for people who are solely suffering from a mental illness. But with that, we now have actually like 5 years of data from 2016 to 2021 about who has been accessing MAID, how many times like MAID have been done in the last 5 years. And I just actually thought the 2021 report to be like really interesting and like worth even like a 5-minute glance from like the federal government's website. But it turns out in the last 5 years between 2016 and 2021, there's been about 31,000 MAID deaths all across the country. And like overall on an annual basis, this type of like death is only maybe like 3% of all deaths like in Canada in that particular year. So it's still like it's growing like in terms of people starting to do it or even like consider it, but it's not, we talk about like floodgate issues a lot in law and how like every time like the law changes, you're gonna have like all these people like doing something. And here, I think you actually kind of see things play out like fairly slowly. I think like the public's being educated, professionals are being educated, and even though it's expanding, it's not going at this like crazy pace that should cause anybody perhaps like too much worry. So with that, let's actually talk about who is eligible for MAID and how does this process work. Raphael, why don't you tell us about it from the perspective of those who are terminally ill?
Absolutely. So I think this goes a little into what you were saying, that there hasn't been a rush. There's a very well thought out process here with several steps. We can look at the initial criteria for who is eligible for this. And initially, you have to be an adult. You have to be 18 and over, and you have to have decision-making capacity. So that already limits right at the beginning. Then you also have to have access to publicly funded healthcare services. And then after that, you still have to make a voluntary request that is not the result of external pressures. So they're really concerned about family members, friends, anyone pressuring people into this, vulnerable, especially elderly people who may be having caretaking burdens, and they're very aware and alive to this issue. And they'll be sure to really question the individual, make sure none of those criteria are present. Then they also have to give the informed consent to receive MAID. This means they really have to understand what it is, what it entails. This is final. It's medical assisted dying, so there is no coming back, of course. And that they've received all of the information about how this process is going to go forward, how long it's going to take, possible side effects or complications. And then after that, you also have to have a serious and incurable illness, disease, or disability. As of now, this excludes mental illness, as the reading was saying, and it was meant to include mental illness as of March 17, 2023. But a bill C-39 was just tabled in Parliament, and that's proposing extending it for another year. So Parliament really has time to consider all the aspects and issues that may arise from allowing mental illness to be one of the criteria. And then going forward, you also have to be in an advanced state of irreversible decline in capability. So it can't just be that you're sick, it has to be a continuing decline in health. That's a really important aspect. And then lastly, there has to be an enduring and intolerable physical or psychological suffering that cannot be alleviated under conditions the person considers acceptable. So there is some subjectivity there for the person suffering to say, this is not tolerable for me.
And so how, if someone sort of like has questions about whether they qualify, and once they've talked to like their medical professionals and it turns out like they do, what then is that process like?
So the next step, there's a safeguard that they have in place starting in 2021 from the Quebec case law, and it's divided into two categories: when death is reasonably foreseeable and when death is not reasonably foreseeable. So first I'll go into when death is reasonably foreseeable. So initially, the person who's suffering has to make a request in writing, and there has to be one independent witness. Now, this independent witness can be a medical healthcare professional. So let's say a doctor or nurse practitioner in the hospital where you're receiving treatment. After that, you have to go with two independent practitioners. That means a doctor or, again, nurse practitioner who have to assess your eligibility for medically assisted death. This review process is quite thorough. They're going to go through the criteria I just mentioned before. And again, the person requesting can withdraw at any time. It can be the second before the procedure. It can be months before the procedure. At any moment, they can say, I don't want to do this anymore. Let's stop. So that's a really important part of it as well. Even if you do sign, you're assessed to be eligible, say no, and it's done. And then right before, there's also a requirement that immediately before the procedure is administered for medically assisted death, they have to request consent from the person. And they have to confirm that they do not wish to withdraw. Now, at this point, there is a caveat. So let's say the person is in a state of decline with mental capability. They can actually waive this for foreseeable deaths and say to the doctor, you know what, at the time that I want to have MAID applied to me, it is highly likely I will not have capacity to consent or withdraw. So they can say, here's my waiver, it's written, and again, signed with the one witness, an independent witness, saying, I will not consent immediately before, but you have my consent right now. So if at the time of MAID, I'm not capable, you can still go ahead. And then we have the second area, which is where death is not reasonably foreseeable. Again, a lot of the criteria are the same. So you have to have the request in writing with one independent witness. You have to have two doctors or nurse practitioners confirm that you're eligible and meet the criteria. You can withdraw consent at any time. But here's where it starts getting a little different. You must be informed of available means of appropriate ways of relieving your suffering. Essentially, they're saying, death is not guaranteed. We want you to make sure there aren't alternate ways for you to relieve this. So this means you have to discuss this with those two practitioners, which were mentioned before, who can assess your eligibility. So you're going to have this discussion, make sure that you understand the alternate pathways, if there are any. And then it can be shortened as well if there's to 90 days. So the consent, the eligibility consent, that can be shortened to 90 days in the event there's capacity issues. You don't have the same opportunity to do the waiver like you do where death is reasonably foreseeable, but you can shorten that period to 90 days. And then again, there's also, you can withdraw consent up to immediately before, and you have to give the consent immediately before the MAID procedure is applied.
That's great. Yeah, no, that's a really thorough like walkthrough of like who's eligible and like the different processes for those who are terminally ill and those who are not. You know, when I was looking at this, I thought, you know, the idea that like this is for people with serious incurable illness, they are in an advanced state of irreversible decline, and they have enduring intolerable suffering. In my head, I was just trying to think about like, what does this actually like mean? Who are these people? And that's why I found like that report from 2021 to be so illuminating, because it turns out that in 2021, the bulk of the people receiving MAID, the people who like qualify based on, you know, sort of like all the like different words I just said, they were cancer patients. So over 60% of them were cancer patients, and that it's even like a smaller portion of like the whole that they end up being people with like, say, neurodegenerative diseases like ALS, even those sort of like, I think like my concept of MAID and maybe like all the advocacy around MAID has been, you know, coming from like that group of like patient care and like medical care advocates. And, you know, the stats also talk about the nature of the suffering itself that are reported by people, and, you know, the inability sort of like to cope with pain, or at least like in this like very specific way of just inadequate like control. That's actually only like sort of like maybe like the third most popular thing that is reported as a, you know, reason for MAID. And the first was the loss of ability to engage in meaningful activities. Then the second is the loss of ability to perform activities of daily living. And then it is about the pain management. So I think like for me, just like as a human person, like think about what it must be like to be like suffering from like such a serious, like, you know, debilitating like conditions, you know, it is hopeful to see like maybe those who are suffering from like just like immense pain, if they're still able to like enjoy life in some way, those people are choosing to continue with life. But it's only when, you know, you really aren't able to enjoy life in any way, you know, that's when, you know, you come to like sort of like this fork in the road, and, you know, you're asking for help, and you're like making this decision for yourself. So I'm really glad this like regime is here, and, you know, the fact that the federal government needs more time to like sort of think of things through further before opening it up to individuals with mental illness. I know nothing about that and can't weigh in, but it's an encouraging sign forward that this group is not being excluded. The fact that we need more time in order to include them, I think it's a better sign than not.
I would agree. It points towards the thoughtfulness that's going to this process, understanding the seriousness, that it's not a light decision you can make. It's sad, it's tragic, but it's important. Like I said, it's for some people, it's the better path forward. And yeah, the governments take it seriously, and
Yeah.
hopefully we'll see.
Right.
Sorry.
And for those of us in estates and trusts, it's just important to sort of like maybe remind family members that this is not like a decision that someone with a power of attorney can make, or guardianship of personal care. It really is like a very individual decision that has to be made by that person while that person is still capable of making it, subject to a few of those exceptions that Raphael had talked about. Okay, so I think this brings us to the end of our podcast. Until next time, I want you to thank you for listening. I'm Dorren.
And I'm Raphael Leitz.
Should you have any questions, please email us at info@hallandhall.com or contact us through the contact page on our website. Thanks.
Take care.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hallandhall.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.